Hello dear students. Today we are going to discuss preventive detention laws, policy, safeguards and judicial review. The word preventive is used in contradistinction to the word punitive. It's not a punitive but a preventive measure. Preventive detention is the most contentious part of the scheme fundamental rights in the Indian Constitution. The Article 22, Clause 3 of the Indian Constitution provides that if a person is arrested or detained under law providing for preventive detention, then the protection against arrest and detention under Article 22, Clause 1 and Article 22, Clause 2 shall not be available. Preventive detention should be carefully distinguished from punitive detention. Punitive detention is punishment for illegal acts done. Preventive detention, on the other hand, is action taken beforehand to prevent possible commission of crime. Preventive detention, thus, is action taken on the grounds of suspicion that some wrong actions may be done by the person concerned. Preventive detention can, however, be made only on 4 grounds. Number 1, maintenance of supplies and essential services and defense. Number 2, foreign affairs or security. Number 3, security of the state. And number 4, maintenance of public order. A person may be detained without trial only on any or some of the above grounds. A detainee under preventive detention can have no right of personal liberty guaranteed by Article 19 or Article 21 of the Indian Constitution. Now, dear students, let's discuss the historical perspective of preventive detention. India has a long history of preventive detention. India is one of the few countries in the world whose constitution allows preventive detention during peacetime. The opponents to this law say that these provisions are without any safeguards that elsewhere are understood to be basic requirement for protecting fundamental human rights. For example, the European Court of Human Rights has long held that preventive detention is unlawful under the European Convention of Human Rights. South Asian Human Rights Documentation Center recommended in its submission to the National Commission to review the working of the Constitution in August 2000 to remove the provisions of the Constitution of India that explicitly permit preventive detention. The following are some historical landmarks related to preventive detention in India. The first Preventive Detention Act during the British rule was Bengal Regulation 3rd of 1818. The government was empowered to detain anybody on mere suspicion. Rule 26 of the rules framed under the Defence of India Act 1939 allowed the detention of a person if it was satisfied with respect to that detention was necessary to prevent him from acting in any manner prejudicial to the defence and safety of the country. Post-independence, the first Preventive Detention Act was passed in 1950. The validity of this act was challenged in the Supreme Court in the A.K. Gopalan versus State of Madras. The Supreme Court held this act constitutionally valid except some of its provisions. It was allowed to lapse after some years. In 1971 came the Maintenance of Internal Security Act, popularly known as MISA. It was basically a modified version of the Preventive Detention Act and was abolished in 1978. In 1974, the Conservation of Foreign Exchange Regulation and Prevention of Smuggling Activities Act, popularly known as COFEPOSA, while the MISA was directed against subversive political activities, the COFEPOSA was also directed against subversive political economic activities. In the heat of terrorism in Punjab, the Terrorist and Disruptive Activities Act, or infamous TADA, was enacted in 1985. It was renewed in 1989, 1991, and 1993 and lapsed in 1995 due to increasing unpopularity and widespread allegations of abuse. The main abuse was that a confession before a police officer even though being given under torture was admissible as evidence in court. Preventive detention powers of the government were further enhanced by National Security Act, popularly known as NASA, of 1980. Another similar act of prevention of terrorism ordinance, POTO of 2001, came into force. Both TADA and POTO were later succeeded by another controversial law known as Prevention of Terrorist Activities Act, POTA, during 2002-2004. This act was supported by the NDA government but later was scrapped by the UPA government. After the Bombay attacks of November 6, 2008, Indian Parliament enacted another anti-terror law known as Unlawful Activities Prevention Act, UAPA. Now, dear students, let's discuss preventive detention, Article 22 of the Constitution of India. Article 22 of the Constitution provides preventive detention laws. Article 22 states that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall be denied the right to consult a legal practitioner of his choice. Every person who is arrested and detained in custody without the authority of a magistrate within a period of 24 hours of such arrest. Of course, the above does not prevent the state from enacting the law for preventive detention with certain safeguards like the advisory board, etc. Article 22 deals with two separate matters. Number 1, persons arrested under the ordinary law of land, and number 2, persons detained under the law of preventive detention. The first two clauses of Article 22 deal with detention under the ordinary law of crimes and lay down the procedure which has to be followed when a man is arrested, and the remaining clauses 3, 4, 5 and 6 deal with the detention under preventive detention law and lay down the procedure which is to be followed when a person is detained under that law. Clauses 1 and 2 guarantee 4 rights to the person who are arrested under the ordinary law. The right to be informed as soon as may be of ground of arrest, the right to consult a lawyer of his choice, the right to be produced before a magistrate within 24 hours, and the freedom from detention beyond the set period except by the order of the magistrate. The above 4 fundamental rights guaranteed to arrested persons by clauses 1 and 2 of Article 22 are available to both citizens and non-citizens and to persons arrested and detained under any law providing for preventive detention. The objective of preventive detention laws is to prevent a person from committing a crime and not to punish him as is done under punitive detention. Preventive detention has not been unknown in other democratic countries like England and Canada, but their recourse has been to have it only in wartime. In A.K. Gopalan v. State of Madras, 1950, the Supreme Court expressed a view that the detainee could not claim the freedom guaranteed by Article 19, Clause 1, Subclause D if it was infringed by his detention. But this view of the court was changed in R.C. Cooper v. Union of India, 1970, and in Maneka Gandhi's case, the court expressed the view in these cases that a law relating to preventive detention must satisfy not only the requirements of Article 22, but also the requirements of Article 21 of the Constitution. The legislative capacity of Parliament or the state legislatures to enact a law of preventive detention is, however, limited to clauses 4 to 7 of Article 22, which lays down 5 safeguards for a person subjected to such detention. The scheme of these clauses is to classify preventive detention in 3 categories. A preventive detention up to 2 months, provision for which may be made either by Parliament or a state legislature. In such a case, no reference may be made to an advisory board. However, Constitution 44th Amendment Act 1978 has substituted a new clause for Clause 4, which now reduces the maximum period for which a person may be detained without obtaining the opinion of the advisory board from 3 months to 2 months. The detention of a person for a longer period than 2 months can only be made after obtaining the opinion of the advisory board. Preventive detention for over 3 months, subject to safeguard of an advisory board consisting of persons qualified to act as High Court judges. No person can remain in preventive detention for more than 3 months unless the board holds that, in its opinion, there are sufficient causes for detention. The Supreme Court has held in Puranlal Lakhan Lai versus Union of India 1958 that such detention is possible if Parliament prescribes by law the circumstances under which the class or classes of cases in which a person may be detained over 3 months without reference to advisory board. Parliament may also prescribe the maximum period for which a person can be detained in the above cases. This provision, it has been held, is merely permissive and does not oblige Parliament to prescribe any maximum period. Further, Parliament can prescribe by law the procedure to be followed by advisory board in an inquiry under Clause 4. Now, dear students, let's discuss safeguards against arbitrary arrest and detention. Article 22. The following safeguards have been provided to a detainee. Number 1. Grounds of detention must be communicated. Article 22, Clause 5 gives the right to the detainee to be communicated the grounds of detention as soon as possible. The detaining authority making the order of detention must as soon as possible communicate to the person detained the grounds of arrest and to give the detainee the earliest opportunity of making representation against the order of the detention. The Clause 5 of Article 22 imposes an obligation on the detaining authority to furnish to the detainee the grounds for detention as soon as possible. The grounds of detention must be clear and easily understandable by the detainee. In Ram Bahadur versus State of Bihar 1975, it has been held that where the order of detention is founded on distinct and separate grounds, if any of the grounds is vague or irrelevant, the entire order must fail. In Fogla and S.K. Jalil versus State of West Bengal 1975, where one of the reasons for detention was not communicated to the detainee, it was held that detainee had no opportunity to make an effective representation to the government, and therefore the detention was violative of Article 22, Clause 5 and must be set aside. In Shafiq Ahmed versus District Magistrate Meerut, it was held that even where one of the grounds was found to be bad and unsustainable, the detention under NASA would not be vitiated if remaining grounds are valid. There is no obligation to provide to detainee prior to his arrest. Section 3 of RTI Act 2005 gives right to information to all the citizens, and under Section 2, Subclause J, right to information means the information accessible under the Act which is held or is under the control of public authority. Under Clause 5 of Article 22, grounds of detention are to be served on detainee after his detention. Therefore, the provisions of Section 3 of RTI Act cannot be applied at pre-detention stage. The state is not under any obligation to provide the grounds of detention to a detainee prior to his arrest, and detention was held by the Supreme Court in Subhash Popatlal Dev versus Union of India 2012. Number 2. Right of representation. Article 22 imposes an obligation upon the government to afford the detainee the opportunity to make representation under Clause 5 of Article 22. It makes no distinction between order of detention for only 2 months and less and for those for a longer duration. The obligation applies to both kinds of orders. It's clear from clauses 4 and 5 of Article 22 that there is a dual obligation on the appropriate government and dual right in favor of the detainee, namely, to have his representation irrespective of the length of detention considered by the appropriate government, and to have once again, in the light of the circumstances of the case, considered by the board before it gives its opinion. If in the light of the representation, the board finds that there is no sufficient cause for detention, the government has to revoke the order of detention and set at liberty the detainee. In Balchand Chaurasia versus Union of India, 1978, the representation was filed by the detainee through his counsel. The government did not consider the representation and approved the detention on the ground that it was not filed by the detainee himself, but by his counsel. The Supreme Court held in matters where the liberty of the individual is concerned and a highly cherished right is involved, the representation should be considered liberally and not technically so as to frustrate or defeat the concept of liberty which is guaranteed by the Article 21 of the Constitution. As the representation was not considered at all by the government, which it was duly bound to consider, the detention order was vitiated and detainee is to be released forthwith. In Sheila Devi versus Mohan Saroop, 1987, the grounds of detention communicated to the detainee were not legible. The legible copies of documents were supplied to him later on. The detention order was confirmed before the supply of legible copies of documents. Court held that it was violative of Article 22 and he was denied the opportunity of making representation and hence entitled to be released. Number 3. Advisory Board. Article 22 provides that the detainee under the Preventive Detention Law shall have the right to have his representation against his detention reviewed by an advisory board. If the advisory board reports that the detention is justified, the government may fix the period of detention. The advisory board must conclude its proceedings expeditiously and must express its opinion within the time prescribed by the law. Failure to do that makes detention invalid. Along with its opinion, the board must forward the entire record to the government, who is supposed to take a decision on the perusal of the entire record. The Constitution 44th Amendment Act 1978 has amended Article 22 and reduced the maximum period for which a person may be detained without obtaining the opinion of the advisory board from 3 to 2 months. The detention of a person for a longer period than 2 months can only be made after obtaining the opinion of the advisory board. The amendment has also changed the composition of the advisory board. It shall now be constituted in accordance with the recommendations of the Chief Justice of the appropriate High Court. It shall consist of a chairman and not less than 2 other members. The chairman shall be sitting judge of appropriate High Court and the other 2 members shall be the sitting or retired judge of High Court. Thus, advisory board shall be an independent and impartial body that is free from executive control. The amendment thus provides 2 categories of preventive detention. First, detention for a maximum period of 2 months under a law made by a legislature. Second, detentions for a period longer than 2 months, provided the advisory board gives its opinion in favor of it. It's a safeguard against executive high-handedness. If the advisory board reports that the detention is not justified, the detained person must be released. If it reports that the detention is justified, the detaining authority will determine the period of detention. The advisory board is bound to submit its report before the expiry of the said period of 2 months. Failure to do so would render the detention illegal. In Abdul Latif Abdul Wahab versus B.K. Jha, 1987, petitioner was in jail awaiting trial on a charge of murder and was due for release on June 23, 1986. On that day, an order for preventive detention was made under the Gujarat Preventive of Antisocial Activities Act 1985. On that date, there was no advisory board in existence to which a reference could be made under Section 11 of the Act, and whose report was required to be obtained within 3 months under Article 22, Clause 4 of the Constitution. On August 7, 1986, when the order of detention on 23 June was revoked, a fresh order of detention was made. The advisory board made its report on September 26, 1986, which was more than 3 months after the first detention order, though within 3 months of the second order of detention. The court held that this detention order was illegal, being violative of Article 22, Clause 4, which required that the report of the advisory board must be obtained within 3 months from the date of detention. This requirement cannot be evaded by making successive orders for detention before expiry of 3 months of the earlier order of detention. It is not sufficient to say that the procedural requirements of the Constitution have been complied with before the date of hearing the case. The detention order was passed knowing fully well that there was no advisory board in exercise to whom a reference could be made and a report obtained as required by the Act and the Constitution. Such a casual and indifferent approach to citizens' rights has to be deprecated. With this, I conclude today's lecture on preventive detention laws, policy, safeguards, and judicial review. Hope you've enjoyed the session. For now, it's time to say goodbye. Stay blessed.